Good evening. Today we will be talking about the Priceline.com terms and conditions. This presentation is brought to you by Kiera Emerson. Priceline.com has decided to evaluate its term of use, and I have been assigned to analyze the website's user agreement. I will look closely at the part of the Priceline user agreement, sections A through F. Priceline is an online travel agency that helps its users find accommodations and transportation via discounted prices. The site launched in 1998 with just the ability to book airline tickets. Since then, the site now offers discounts for cruises, hotels, rental cars, and hosts millions of visitors each month. Question 1. Is it a valid contract? Keep in mind, according to the American Bar Association, websites are not required to have a terms and conditions page by law. However, in the instance that a site provides goods and services to a consumer, the Consumer Protection Law requires that certain information is disclosed prior to users making a purchase. The terms and conditions found by clicking the link at the bottom of Priceline's website are considered a valid contract. The information contains detail on how a user can resolve disputes, delivery terms, refund policy, and copyright infringement information. These items are drafted in a clear manner without technical jargon and are not mixed in with irrelevant information such as marketing messages. Question 2. Are visitors bound to it, or should they have to click I agree? Users who simply visit Priceline's website are not bound to these terms. The terms do not come into effect until an active purchase of a product or service has been made. Due to the nature of the company not being required to list terms and conditions, the user does not have to click I agree to be bound to these terms. In fact, it clearly states in the first section of the terms and conditions that a user must agree with the terms in order to continue using the website. Additionally, if a user does not agree with the terms, they are required to notify Priceline in writing via certified mail and must discontinue use of the site until further communication is received from Priceline. Although there are no requirements to click I agree prior to making a purchase, once a user has made a selection and decides to proceed with the services offered by Priceline, a clear message is provided which informs the user that they are subject to the terms and conditions listed on the Priceline website after following through with their purchase. This makes these terms and conditions enforceable, according to the ABA. Question 3. If you have a dispute with Priceline, can you sue them? Why or why not? The answer to this question can be found in detail in Section A titled Disputes and Arbitration of the Terms and Conditions Statement. In this section, Priceline discusses arbitration and disputes and makes a clear notice that users are not allowed to bring forth any class action suit. The section reads, it requires that any and all claims must be resolved by binding arbitration or in small claims court, and it prevents you from pursuing a class action or similar proceeding in any forum. These limitations apply to any claims against Priceline, its subsidiaries or affiliates, any travel service providers or companies offering products or services through the site. In arbitration, dispute is resolved by an arbitrator instead of a judge or jury. The arbitrator's decision will generally be final and binding with no right of appeal. Arbitration procedures are simpler and more limited than court procedures. The second part of this section outlines another option, allowing an exception for a case to be brought forth in small claims court within the jurisdiction of the user's billing address. Lastly, if the user chooses not to proceed with arbitration or small claims, the last option is to file a notion with the United States District Court for Connecticut, or if there is no federal jurisdiction over the action, in the courts of the state of Connecticut, located in Fairfield County, Connecticut. In conclusion, yes, a user can sue them as long as it falls within the guidelines mentioned in the Terms and Conditions section titled Disputes and Arbitrations. Question 4. What changes would you recommend? As the terms and conditions read very clearly, using a legible font, easy to access, can be printed and saved at the user's discretion, and do not contain any unnecessary jargon, I would not change anything. For the purposes of building trust, which has been a pillar in the digital marketing program throughout all courses, I would incorporate a pop-up once a user reaches the landing page to read and review the terms and conditions prior to continuing to the site. This provides transparency and allows attention to be brought to these terms prior to the user interacting with the website. Thank you.